All right. Hello, everyone. Welcome to Skeptical Inquirer Presents. This is a series of live online presentations from experts who are devoted to advancing science over pseudoscience, media literacy over conspiracy theories, and critical thinking over magical thinking. I'm your host, Leanne Lord. I'm an award-winning stand-up comedian, author, and Center for Inquiry Fellow. Hello, and thanks to those of you who are watching the recording of this episode. And of course, welcome to those of you who are joining us live. You have the opportunity to ask questions of our guests by typing them into the Q&A box, and we'll get to as many of them as we can. But to all of you, please be sure to check out the latest episode of Point of Inquiry, available wherever you get your podcasts. And if you haven't already, round out your reading list with Skeptical Inquirer magazine. You can subscribe to it at skepticalinquirer.org. And you guys, SciCon 2024 is almost here, October 24th through the 27th in Las Vegas. Now, happy September. I know it is for me, as it is my birthday month. I actually celebrate for the entire fiscal quarter to give everybody a chance to, get their gifts in. I know. Speaking of gifts, September is National Bourbon Month, and bourbon is a great gift given tonight's topic, the elections and the Supreme Court, on the brink of the total collapse of science and secularism. As you can see here at CFI, we like to keep things light. We sugarcoat it just a bit, erring on the side of hope, painting an optimistic picture that might give you the strength to go on instead of drowning yourself in a bathtub of bourbon. I I probably should have had a V8. Anyway, tonight's religious right wing and their enablers on the Supreme Court are not just poised to abolish the separation of church and state. They seemed determined to repeal all modern progress made by humanity in the past 300 years by repealing the very Enlightenment itself. While this is seriously harshing my birthday buzz, sticking our heads in the sand will not change the facts. The monsters are out from under the bed, the zombies are over the wall, and the line must be drawn here, this far, no further. But resistance, my friends, is not futile. Here with the sobering facts is CFI's own Edward Tabash, or Eddie as we call him. He's a constitutional lawyer in Los Angeles and the chair of the board of directors for the Center for Inquiry. He's the son of an Orthodox rabbi and an Auschwitz surviving mother. After decades of research and reflection, Eddie has concluded that the universe is natural, with no supernatural beings or occurrences, aside from the crazy sale I got on this bourbon. He is known for his involvement in defending the separation of church and state and for representing the atheistic point of view in debates against religious advocates. So, if you're hiding under the covers because you feel like the world, or at least our corner of it, is slipping into the abyss, I get it, because it is. It always is. But before we disappear into the darkness, let's welcome to the Skeptical Inquirer Presents screen a man who's fighting to keep the lights on, CFI's legal eagle, Eddie Tabash. Eddie,
Thank
my
you, Leanne.
dear, you have the con.
Thank you. Thank you, Leanne. Leanne is really such a treasure. Her comedy is so funny. She can actually bring the light to an otherwise very sad world. And I always say that Leanne is, for me, as an atheist, Leanne is the only person on earth that can get me to say, praise the Lord. So the elections, 2 calendar months from today, we will have one of the most consequential presidential elections we've ever had. Now, CFI is a nonprofit entity, does not endorse or oppose candidates for any elective office, but we can comment on the actual religious tyranny and accompanying rejection of science
Hello, everyone. I'm not sure what happened just now. Yeah, well, yeah, thank you. My tech is saying he froze. I wasn't sure if he was just frozen for me. Um, and then we lost him. We were having some tech issues earlier, you guys. So if you can just hang on and be patient. I'm sure Eddie has realized this and he will log back in shortly. Um, this is one of those moments where I wish I had gone to law school, clerked under Eddie so that I could fill in.
What?
Hey,
Did I get
oh,
disconnected?
well, you froze and
Well, I
then you
never
dropped
freeze.
out,
Okay, I dropped
and
out.
but you're back. That's what's
Okay,
important.
I'm just going to begin all over again, and I'll
Well,
because
we
I.
know who you are.
Okay, all right. So we all okay.
And if you want to make me laugh again by saying praise the Lord,
Yeah.
I'll take
Okay.
that.
Well, I'm just going to begin the presentation because it's important,
Yes,
and I hope the doesn't sabotage my Zoom link anymore. But
no worries. Do
what
your
I
thing.
said was that 2 calendar months from consequential presidential elections we've ever had, when CFI, as a nonpartisan entity, though we will not endorse or oppose candidates for office, we can and we must comment on the actual religious tyranny and accompanying rejection of science that will result from any presidential administration involving the appointment of religious right wing judges to the Supreme Court and to all other levels of the judiciary. And what I said before falling off was that given the stakes in this election, we now face in America two possible futures. One, the one we want, offers the prospect of an ongoing march into ever expansive Enlightenment values, in which believers and non believers are equal before the law, and laws and regulations based on evidence and science are made by responsible officials in the executive and legislative branches of government. Most importantly, such laws and regulations would be, like they used to be, upheld by judges who are not motivated by an ideological commitment to abolish modernity and impose a theocracy. The other possible future confronts us with a flurry of oppressive laws passed by Congress, state legislatures, and other local branches of government. These laws will overtly favor religious belief over non belief. They will ignore science, both generally and medically, in order to appease whatever social interest would make more money, even if both the planet and the public would be placed in grave jeopardy. These laws will have to be upheld by all federal and state courts because the current religious right wing supermajority of 6-3 is already requiring the rest of the country to uphold these types of rules and regulation. There will be nothing to stop religious oppressors from using the police power of the state to destroy our most precious freedoms. We face the awful tragedy that the one institution of government that we could most reliably trust to protect our personal freedoms and to make decisions based on reason from the late 1940s onward has now become a weapon for imposing religious tyranny and ignoring the very science it used to revere. The court combined eroding the separation of church and state and disregarding science in striking down health regulations designed to limit the spread of COVID. Now, this is a window into how the current religious right wing majority combines flouting science and promoting theocracy as part of the same trajectory of reversing decades of the proper interpretation of the Constitution. In 2020, in Roman Catholic Diocese of Brooklyn versus Cuomo, the court struck down state restrictions on the number of people who can gather for worship services. In dissent, Justice Breyer pointed out that the rules established for religious activities also applied to similar meetings at public lectures, concerts, theatrical performances, where, as in places of worship, this is very important, people were more likely to be gathered together more closely for longer periods of time. Further, Breyer argued that the court's precedents recognize the importance of courts granting officials broad discretion when they must act on the basis of uncertain and swiftly changing medical and scientific information, as in the situation New York was facing with COVID. Breyer lamented the majority's decision because members of the scientific and medical communities tell us that the virus is transmitted from person to person through respiratory droplets produced when people in a group sing, talk, cough, or breathe near each other. He also cited briefs of the World Health Organization and the American Medical Association. Thus, according to scientific experts, not religious ideologues, scientific experts, the risk of transmission is higher when people are in close contact with one another in indoors or other enclosed spaces. Breyer emphasized how the court majority was intentionally disregarding crucial scientific information that would reduce the harm of COVID, just so that religious objectors could be exempt from complying with these essential laws, even if these exemptions jeopardized public health. In 2021, deciding South Bay United Pentecostal Church versus Newsom, the 6-3 religious right-wing majority voted to strike down a number of restrictions that California had in place regarding indoor religious services. There were a few sets of restrictions the court dealt with. One restriction prohibited all indoor services in areas of the state where it had the highest infection rates. Another limited religious gatherings in other parts of the state to 25% of capacity. The third prohibited chanting and singing in all indoor services. The result was that the 6-vote supermajority allowed indoor religious services in all areas of the state against scientific advice, regardless of infection level. Now, they did uphold the ban on chanting and singing because to not do that would have made them look even more ridiculous than they usually do. There were only 3 justices on the church-state separation and pro-science side, Breyer, Kagan, and Sotomayor. Kagan wrote a powerful dissent. She showed that California did not, this is very important, single out religious gatherings for any fewer rights. The state grouped together political meetings, attendance at lectures, movies, plays, along with everything else, without discriminating on the nature of the event, as long as the gatherings themselves were dangerous in terms of spreading the virus. Religious gatherings were grouped with other types of gatherings based on proximity and the length of time any danger of exposure lasted. There was no effort whatsoever on the part of the state to single out religious gatherings for fewer rights than other similar types of gatherings. In providing preferential treatment for religious gatherings, the majority of the court ignored scientific evidence. California even provided experts showing how shopping for groceries differed from worship services in the amount of droplets to which those engaging in either activity were exposed. Now, Kagan wrote, "This is no garden variety legal error." She sure was right there. In forcing California to ignore the expert scientific findings, the court impairs the state's effort to address a public health emergency. Ignoring scientific findings, the court impairs the state's effort to address a public health emergency. Even going against the best advice of contemporary science, the United States Supreme Court would allow the religious to have special exemptions from necessary virus-fighting laws, even if the public health would be jeopardized. Now, in June of 22, the court brazenly issued a simply unacceptable 6-3 ruling that ignored scientific evidence for how climate change threatens the nation and the world. With no actual constitutional basis, the majority deprived the Environmental Protection Agency of the power granted to it by Congress to curtail greenhouse gas emissions. This preposterous decision was fabricated for no reason other than political support for the business interests of power plant operators and the states in which they are located. The case was West Virginia versus EPA. The court majority voted to strike down regulations that Congress clearly empowered the EPA to promulgate under the Clean Air Act. These regulations authorized regulating power plants that emit greenhouse gases, which severely aggravate climate change. Now, just a week before this idiotic ruling, the court majority obliterated almost 50 years of protecting abortion rights under the Constitution. A rationale used by the court was that the term abortion appears nowhere in the Constitution. Yet, in this EPA case, the court majority invented out of nowhere something called the Major Questions Doctrine in order to have an excuse to invalidate the powers to regulate greenhouse gases that Congress conferred on the EPA. Supposedly, under this fabricated Major Questions Doctrine, Congress has to be even more specific than it was if it wants to authorize the EPA to regulate such power plants. There is no basis in the Constitution for such a requirement. The opposite is true. Under the Supremacy Clause of the Constitution, such congressional delegation of power to a specialized agency with expert knowledge in a given area is clearly allowed. Now, let's look at Justice Kagan's hard-hitting and marvelous dissent. She says, today the court strips the Environmental Protection Agency of the power Congress gave it to respond to the most pressing challenge of our time in terms of our environmental survival. She concluded her dissent by saying the stakes are high, yet the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions. She then says, this is just fabulous the way she words this, the court appoints itself instead of Congress or the expert agency as the decision maker on climate policy. I cannot think of many things more frightening. Well, we certainly join Justice Kagan in being frightened. Now, what is percolating up to destroy our freedoms from the religious right? Project 2025 is the religious right-wing effort to destroy the separation of church and state by empowering the executive branch of government to impose religiously motivated attacks on our freedoms. Starting in 2022, the Heritage Foundation took the lead in creating an agenda for restructuring the executive branch of government so as to make it the servant of a new theocracy. It required the federal government to have less authority over public education, allowing for more inclusion of religious beliefs into classroom curricula, like what Oklahoma is trying to do presently. It would support school choice, which means states would have greater liberty to support sectarian schools with taxpayer money. It would try to get the FDA to reverse its approval of mifepristone, the abortion pill. Wherever its use would still be somehow legal, Project 2025 would no longer allow this medication to be available through the mail. It could only be dispensed in person. Until abortion could be banned completely, states would be threatened with withholding of financial assistance unless they reported every miscarriage and abortion that takes place within their borders, including the reason for any such abortion, if that can be determined. They would also defund Planned Parenthood. They would repeal existing LGBTQ rights and protections. Get this, eliminating workplace anti-discrimination and undoing constitutional protection for marriage equality. It would also be the largest expansion of presidential power that has ever taken place. Even Richard Nixon from inside his grave would say, well, the president shouldn't have this much power. 10 years ago, if such proposals were enacted into law by Congress or attempted to be imposed by presidential executive order, we could still rely on at least a 5-4 Supreme Court majority to declare such measures unconstitutional. Now, even if we're able to persuade Chief Justice Roberts that some of these laws and regulations are unconstitutional, the religious right would still prevail on everything by a 5-4 vote. Now, I have to bring before all of you, my colleagues, something simply almost too horrible to contemplate, but it's happening. Over and above the religious right-wing takeover of the Supreme Court, there is another incredibly dangerous effort currently underway. Now we must address the looming greatest threat to the Constitution we've ever confronted. Like a torpedo that travels underwater, frequently undetected until it strikes its target, the religious right has been quietly persuading states to pass resolutions calling for the first nationwide constitutional convention since 1787, pursuant to Article 5 of the Constitution. At such a convention, the entire Constitution in its present form can be completely eliminated. Any amendment can be passed. A completely new Constitution can be produced. In order for such a constitutional convention to take place, all houses of 34 state legislatures must vote for it. A convention call that passes in this way cannot be vetoed by a state's governor. Today, a shocking 19 state legislatures have passed a resolution calling for such a convention. In 7 other states, at least one house of the legislature has passed it. The 19 states that have fully voted to call the convention are Georgia, Alaska, Florida, Alabama, Tennessee, Indiana, Oklahoma, Louisiana, Arizona, North Dakota, Texas, Missouri, Arkansas, Utah, Mississippi, Wisconsin, Nebraska, West Virginia, and South Carolina. The 7 states and at least which one house of the legislature has voted for this are New Mexico, Iowa, South Dakota, Virginia, North Carolina, New Hampshire, and Wyoming. It's important that we understand that whatever proposed changes or entirely new constitution that would emerge from this convention would require ratification by all houses of 38 state legislature. That's only 4 more states than would be necessary to convene the convention in the first place. Such a convention could easily result in an entirely new constitution that would declare the United States to be a Christian nation. It could revoke the civil rights of atheists. It could eliminate free expression. Even the religious right-wing Supreme Court Justice Scalia warned against such a constitutional convention. He correctly admonished that such a process would be too open-ended and could result in virtually anything. No kidding. Here are 2 of the proposed amendments such a convention will consider. There is one that would give states the power to refuse to comply with federal regulations and U.S. Supreme Court decisions. This means even if we go back to having a reasonable Supreme Court, and that new court majority rules, for instance, that no branch of government can discriminate against atheists or Buddhists, every state would be free to ignore the ruling. Another amendment would prohibit the federal government from controlling education, energy, and the environment. This means that there could never again be federally mandated uniform laws and regulations to deal with climate change. There could never again be nationwide emission standards. Local public schools could teach creationism and intelligent design, proclaiming them to be scientifically established. This is something we can't risk under any circumstances. All of us must contact our state legislative representatives and tell them to oppose such a resolution. If one house of a legislature has already passed it, we must contact the members of the other house. If it has already passed both houses of the legislature, we must contact our representatives to try to get them to reconsider this whole business, even though it's unsettled if a legislature can reverse an earlier vote to approve. All of this is unsettled. And we certainly don't want the current Supreme Court weighing in to answer these questions that have never been addressed before. One of the main people pushing for this religious right is the religious right-wing Prince of Darkness, Steve Bannon. Other fervent supporters of such a convention are religious right-wing icon James Dobson, Florida Governor Ron DeSantis, former Arkansas Governor Mike Huckabee, and the Heritage Foundation. Church-state separation must be seen as a universally necessary foundation for society. Now, what do I mean by that? What do I mean by the, if you'll permit me, the universalization of church-state separation? We need to reach a point at which support for neutral secular government and adherence to the teachings of science are so pervasive that when someone declares full support for the separation of church and state, from that alone, we would not be able to tell where this individual stands on any other issue or anything else about this person's political affiliations. That means the desire for neutral secular government would pervade people who would otherwise disagree on all other political issues. Former New York Governor Mario Cuomo phrased it very well. He said that it is rank hypocrisy for the religious right to preach to us about limited government and then to turn around and to tell us, the American people, how to apply the judgment of a God that they believe is the true God with respect to our bodies and to our bedrooms. Now, it's very important for the Center for Inquiry to be very clear on this. We have never wanted greater rights for non-believers. In our extensive legal activities, CFI has never advocated for greater rights for atheists, agnostics, and other doubters and dissenters. We've always supported equal rights for everyone. What a horrendous backward step it would be if the United States goes from once having been a nation that protected the rights of conscience of everyone to becoming a country where government can formally look less favorably on those who don't harbor religious beliefs. In April of 2019, we had a frightening display of religious bigotry against atheists from none other than Supreme Court Justice Clarence Thomas. He expressed dismay at why atheists would even take oaths because we don't believe in any supreme enforcer that would punish us if we don't abide by such oaths. Well, Thomas doesn't understand his own religion. Once someone accepts Jesus and is saved, they can't lose their salvation just because they commit perjury. Salvation is by faith, not by conduct. So biblical literalist Christians are the ones who have no incentive to abide by oaths because they believe they are saved for all eternity just because of their faith in Jesus. If you're a Catholic like Thomas, all you have to do is go to confession after you commit perjury, and your sin is wiped away from your heavenly record, the same way that attending traffic school keeps a violation off of your driving record. In June of this year, a reporter attending a dinner sponsored by the Supreme Court Historical Society pretended to be a religious right-winger and secretly recorded Justice Alito agreeing that we must try to return our country to a place of godliness and that our divisions are so deep that we just can't make peace with each other so that one side or the other will have to openly win. Well, he's wrong. We can have a permanent truce in the culture wars. All that has to happen is people like Alito have to learn how to be happy with their own freedom to live as they want and believe as they want without forcibly trying to impose their religious views on the rest of us. By contrast, we adopt the position of former Supreme Court Justice Sandra Day O'Connor, who wrote, "No branch of government can communicate the message to anyone that because of either accepting or rejecting any religious belief, they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the political community." We also subscribe to another way that she expressed the idea of government neutrality in matters of religion when she wrote, "No branch of government can treat people differently based on the God or gods they worship or do not worship. Believers and non-believers, people of every kind of political persuasion or mixture of views, must all come to understand how unacceptable anything other than government neutrality in matters of religion would be." This was cogently expressed during the summer of 1789, when the House of Representatives was considering the wording of what was to become the First Amendment. Representative Daniel Carroll of Maryland, one of the signatories of the Constitution itself, in 1787 said, "The rights of conscience are in their nature of such peculiar delicacy that they will little bear even the gentlest touch of governmental hand." Now, a horrendous example of empowering on-the-job government employees to impose their religion on others took place in the 2022 case of Kennedy versus Bremerton School District. A high school football coach conducted actual prayer sessions with his team and the opposing team on the football field after games. Large numbers of spectators would come down and participate in these prayers. The coach refused to stop holding these prayer gatherings and was suspended by the school district. He sued, and the religious right supermajority ruled in his favor by grossly distorting the actual facts of the case. Gorsuch's majority opinion asserted that the coach offered his prayers quietly while his students were otherwise occupied, and that he made short, private, personal prayers. Gorsuch wrote there was no indication in the record that anyone expressed any coercion concerns to the district about the quiet post-game prayers that the coach asked to continue and that led to his suspension. Gorsuch misstated the facts to assert that unlike private cases where the court ruled that prayer at a school event was unconstitutional, this coach's prayers were not publicly broadcast or recited to a captive audience, and students were not required or expected to participate. In fact, a 16-year-old atheist player said he felt compelled to participate in prayer out of fear that he would be given less playing time if he didn't. Sotomayor's dissent took the unprecedented step of attaching photos to her dissenting opinion, showing the truth about how the coach was conducting these large-scale prayer meetings on the field with both football teams and how spectators stormed the field to participate. She even showed how the police had to admonish parents to stay off the field as these post-game prayer gatherings were so large. Never before has a justice attached photographic evidence to a dissenting opinion in order to refute the erroneous factual claims of the majority. She also reminded the court that it had always held prayers led by school officials to be unconstitutional. The court, unfortunately, also abandoned the Lemon test. This was a method from the 1971 case of Lemon versus Kurtzman of determining if a law or practice of government violated the Establishment Clause. Under this very, very useful three-part test, the court required all government actions to have a secular purpose. Government could not do anything that would have a primary effect of advancing or inhibiting religion, and there could be no excessive government entanglement with religion. Instead, the court now looks at references to historical practices and understandings. This is a disaster. It means that past benighted and ignorant practices will prevail over what the Constitution was designed to guarantee. The court even violates the principles that conservatives cherish the most, looking to the actual text of a constitutional provision and looking for the framers' intent. Instead, the court will now say that historical practices, even if they were dead wrong, will be the yardstick by which to measure the constitutionality of any government action. We knew that this was going to happen, and unfortunately, nationwide tragedy struck. In June of 2022, the religious right-wing majority on the court demonstrated its disregard for well-thought-out precedent and for the lives and well-being of millions of Americans. Yes, we knew this day was coming, yet nothing could prepare us for the grief, health, and life-threatening state actions, deprivation of basic liberty, and prosecution as persecution that the reversal of Roe versus Wade in Dobbs versus Jackson Women's Health Organization has already inflicted on our nation. After 49.5 years, 49 and a half years, almost 50 years, the court overturned its recognition that abortion was a protected constitutional right that state governments could not abrogate, while Alito's majority opinion acknowledged that the Due Process Clause of the 14th Amendment does protect certain rights not explicitly set forth in the Constitution. Such rights must be deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Again, just like in the football coach case, the question should be not if the Constitution was meant to protect a certain right. The question would be, how has it been practiced, even if previous practices got it wrong? But you know what? Let's do this. Let's give Sam Alito, let's give him a concession. Let's play his game. Deeply rooted in the nation's history and tradition. All right, Your Honor, we're saying 49 and a half years should be enough time for a given right to be deeply rooted in the nation's history and tradition. And that's what abortion rights were, deeply rooted in the nation's history and tradition, even though they were also justified by the Constitution when he wrote the majority opinion that took away constitutional recognition for this most basic right. In the past 2 years and 3 months, 14 states have banned abortion entirely. 4 states ban it after 6 weeks, 1 after 15 weeks, 2 after 12 weeks. Let's look at some of these horrors. It's hard to believe that this is America today. In July of 2022, a 10-year-old girl in Ohio was 6 weeks pregnant after being raped by an adult. She could no longer obtain an abortion in that state and had to go to Indiana where an abortion was performed. In Texas, which now allows abortion only if necessary to save the patient's life, a woman's water broke at 18 weeks. By 22 weeks, her cervix was dilated. She was inevitably going to miscarry. She became very ill. A life-saving abortion could not be performed in that state unless she was virtually at death's door. She got very, very sick, but the doctor said they still could not terminate the pregnancy. Finally, when her fever reached 103 degrees, she was deemed gravely ill enough in order for the abortion to be legally performed. All of us colleagues in secular humanism, scientific skepticism, in evidence-based life, where truth, regardless of its ideological or theological implications, is always courageously sought after, we must now look at this sad reality A long, long time ago, in a galaxy far, far away, there was a very different Supreme Court. Since the 1980 presidential election, as many of you know, I've been literally screaming about the danger of a religious right-wing takeover of the court. Well, it's finally happened. The only way we have any possibility of ever again being protected by the types of Supreme Court majorities we had in the past is from now on to treat every presidential election and every election for the US Senate as a referendum on the court. Whether pro-church state separation and pro-science justices can be successfully placed on the court when there is a vacancy will depend on who will be president at the time and what the composition of the Senate will be. Whether it takes the rest of our lives or even a number of generations, we must do everything we can to ensure that there will once again, even if it's someday far off in the future, be a Supreme Court majority that follows reason, science, and the true meaning of the religion clauses of the First Amendment, which is to secure equal rights for believers and non-believers. Right now, our crucial battle in the war to preserve civilization is this year's presidential election. We all know what we have to do. Thank you for listening to me, and I'll be happy to take questions.
Eddie, thank you so much. That was informative and sobering. And let me see, I'm trying to change the view. So we are gallery view for me. All right, great. The technology is working for both of us. All right, we do have questions for you, but I will say in my listening, many times when you were talking about believers or non-believers, my brain translated that very, very simply, white and black, because the United States has not always protected the rights of everyone and has actually actively harmed my community and others. And, once it gets a taste for not protecting one group, that we can see spreads. So I see some very, very natural parallels and allyship there. And if one of us isn't safe, none of us are safe. But Stephen, I am not even going to attempt to pronounce your last name because I truly do not want to butcher it. But this is a question that I think is on everybody's mind. And they ask, is expanding the number of justices on the Supreme Court the best way to alleviate the situation that the Republicans put the country in by not allowing a hearing when there was 7 months left? He doesn't say it, but it's 7 months left to Obama's term, and then speeding up the hearing for a Supreme Court judge at the end of Trump's term.
That's an excellent question. And I hope I don't get disbarred for this and that my colleagues don't run me out of town. But I'm going to be one lawyer who says I have no idea. And let me tell you why.
Okay.
I have no idea because I don't know where it would end. This is not a ideological question. It's a mathematical one. Let's say we expand the court to 11 justices. Then the next religious right administration expands it to 13. The next church state separation pro-choice administration expands it to 17. But then the next religious right administration expands it to 21. I don't know how that will end. I can't predict. It's the same with term limits for Supreme Court justices. It all depends on who is president when each justice is termed out as to whether that justice, whoever it is, whatever they stood for, will be replaced by a pro-church state separation, pro-choice, pro-science justice. So it's such a crapshoot. Again, it's a mathematical prediction. I will say this: if I thought that expanding the court would permanently secure modern secular neutral government, I'd be for it. If I were sure that term limits would do the same, I'd be for it. But mathematically, I don't know how to prognosticate how it'll play out because I don't know who will be in power, who will be in charge when the terms come true. And I don't know when the Supreme Court expands to 51 members if we'll have the majority or they will. So I really
Hilarious. At that point, it's a party. There's a whole industry making justice robes. It's insane. And honestly, I never thought of it that way, but that is incredibly practical, that it is mathematical. Thank you. KK Carney wants to know, does the call for a constitutional convention ever expire in those 19 states that have passed it? Like, is there a time limit? Like, you've got 6 months, you've got a year, you've got 2 years.
That's an excellent question. I don't believe so. I would actually need, if everybody will permit me, to look at, which I really should have, but I didn't, Article 5 of the Constitution. And
You don't have that memorized? I'm stunned.
I have the First Amendment memorized, but I don't have Article 5 memorized.
Well, 5,
Congress can propose amendments. Okay. The Constitution, okay, can also change through, let's see, if I can get the actual wording. Okay. It doesn't seem that, I would have to give it a closer reading, that there is a time limit. It's an excellent question. I do know that when we were pushing for the Equal Rights Amendment, the ERA, some states that first voted against it wanted to change their mind and vote for it. And the argument from the religious right was not that time had gone out, but that once you vote, you vote. But that was not even to call a convention. That was just to amend the Constitution. We've amended the Constitution with amendments many times. This would be the first time since 1787 that we would gather in a constitutional convention where everything is up for grabs. So I really don't know. I would need to explore that further, but that is really an excellent question as to whether some kind of time period would run and we would have a right to say, sorry, you didn't get your 34 states within the allotted time. I promise I will try to get into that and find the least unreliable answer.
I'm not sure if this is, well, Jane wants to know, and I guess, anybody over 30 who forgets what it's like to be a younger adult wants to know if young people are seriously concerned. Do they understand how they need to vote?
I don't know. I do know this, though, that for 20 years, I was the most active man in California in abortion rights. I was the primary speaker and debater for the NARAL affiliates in California. At that time, I saw more activism. My feeling is this, and in fact, earlier today, I just said that to United States Senator from Ohio, Sherrod Brown. And I said, Senator, we have a problem in this country, given how horrendous the overturning of Roe versus Wade is. The outcry is still relatively muffled. The fact that young people aren't in the streets demonstrating over the loss of constitutional protection for abortion rights, I don't know. The fact that still such a large number of women support anti-choice candidates around the country, I don't know if the younger voting generation is cognizant of how close they are to losing freedoms which their parents' generation had, and which for a few generations we took for granted.
Mm.
I have a bad feeling. I don't have the statistics to back it up, but I do feel that however many young voters understand that the religious right wants to hurl their liberties back into the dark ages, not enough of them do.
I'm going to push back just a little bit. Not that the young folks talk to me, they don't.
Yeah.
They don't see me as one of them anymore, which is very shocking and hurtful. But is their outcry muffled, or is the reporting of their outcry muffled? Because I don't think they are as tied to traditional media, and by that I mean, newspapers, magazines, the cable news, network news. They are incredibly active on social media, for good or ill. And while that information is not as accurate as we would like to be, sometimes the networks aren't as accurate as we would like to be. And I'm seeing, and again, this could just be my feed, I'm seeing really angry, very engaged, what the hell type posts. And so that's what gives me a little bit of hope, but perhaps not, they aren't as out there um, or visible as we might have seen, say, in the young folks from the 60s. But the repercussions for
Yeah,
them
well,
doing that.
I'd like you to be right on this one, Leanne, but here's my
uh,
problem. Since Roe versus Wade was overturned, with a number of young people who would be able to vote if they want to, I haven't seen a gigantic enough shift in the American vote that would
mm,
reflect a recognition by all generations, including the younger ones, of what was taken away from us by overturning Roe, even leaving aside the other issues.
mm.
That's what I mean by muffled.
Okay.
That they're the overturning of Roe should have caused a sea change shift in American voting patterns. It hasn't. That's what concerns me.
Okay. Okay. Um, Lawrence is asking, as Alito and Thomas have misstated basic facts in their rulings, can they be disbarred?
Well, okay, disbarred applies to lawyers. Judges,
Oh,
federal judges can only be removed from office by impeachment. This would
okay.
be a dangerous area because it would get into interpretation. The thing to do is we can't remove judges and justices because we don't like how they interpret certain things, because then they'll turn around and do it to judges and justices who interpret things the way we like them.
Okay.
So removal for non-ethical violations is a pretty dicey situation. The only thing to do, again, is the hard way. Make sure that we have the elected people in place to give us the right judges.
Understood. Um, where do you stand on packing the court? Packing in quotes.
Well, yeah, well, I mentioned that earlier when we had the same type of question, increasing the number of it. It's a mathematical question. It's not an ideological one. I would be happy to pack the court if I knew that 10 years down the line, the religious right wouldn't repack it.
Right.
So until we know how it works out mathematically, as I said a few minutes ago, there's no guarantee that by the time we get to 51 justices, the majority will be ours and not theirs. I don't know how to statistically prognosticate in the next 20 years at what point the packing will stop. It's like musical chairs. When the music stops, who has the advantage?
Right.
I
Right.
can't tell.
This question I find horrifying, and I'm embarrassed that I didn't notice it on my passport. Dave, thank you for pointing it out. I actually want to run and go look now. But the crumbling state of the wall between the church and state is shown on my US passport, which mentions God 5 times in the running headers. Who designed this? And has anyone objected? I don't expect you to know who designed it, but my goodness, they snuck that one in, didn't they?
They certainly did. My feeling is it's totally unconstitutional. But if the court wouldn't allow under God to be removed from the Pledge of Allegiance, or in God we trust from the money, they probably wouldn't allow this. In fact, one of the things I didn't have time to mention in the initial presentation is right now we're in a tooth and nail battle with Louisiana that wants to mandate the posting of the 10 Commandments in public school classrooms, even though the court ruled in 1980 that that was unconstitutional. Why are they doing it? The same reason for why Mississippi challenged abortion rights, because they know that they now have a different court.
Mm, got it. Um, I think sometimes, and thank you, Steve, for the question I'm about to ask, we forget, or I forget, that we have very smart people in the room on our side as well. And he wants to know, have the people on our side been preparing for a constitutional convention the way those on the other side have been?
See, that's a very good question. It's a very profound question, because the answer is no in this sense. We would never call for an Article 5 convention where the entire Constitution would be up for grabs, given the current state of the nation. So, just as they are trying to get a constitutional convention through the 34 states they need, we're not. Because regardless of who calls the convention, everything is up for grabs. Today's climate is not one in which we want to risk that. What we have to start doing, this is really important, we've got to start doing, is in case the convention is called, even if it might be too late, we have to make sure we have as many church-state separationist, pro-choice, and pro-free expression delegates to the convention as possible. My feeling is, if this convention is called, what will emerge from it will be a horrific new constitution that will obliterate all our modern freedoms, and we will then have to stop somehow, if we can, ratification by 38 state legislatures.
This begs a question. Is secession an option? The People's Republic of New York declines and secedes?
That is way beyond anything that I want to talk about right now.
Got it. Got it. Note to self, buy bottled water. This is a tricky question for me because I'm not sure I agree with the premise, but I'm not here to agree or disagree. Is democracy still the answer? It's democracy that got us into this mess. Concurrently, should voting still be a right or privilege? Lastly, term limits for all elected officials, including judges. Well, I'm horrified those words even came out of my mouth.
Okay,
But
well,
let's talk about it.
Term limits, again, as I said, it's a mathematical issue. But democracy, there's actually a clear answer. Yes, democracy works if it's a constitutional democracy, like what we've had up to now. A constitutional democracy means that there are certain rights that the majority cannot trample on. So, what that would mean is that if everybody in the entire state, 99% of the people, said the 1% Hindus should not be able to worship at their temple, they wouldn't be able to impose that, even though it's by an overwhelming majority. So a constitutional democracy works when there is a enclave of personal freedoms that are beyond majority reach. The majority will can determine many things, but as long as we have the most essential freedoms beyond the reach of the majority, that's a constitutional democracy, not a pure democracy, and that works.
We are right at 8 o'clock, but you and I talked about this before, and you have some time to go a little bit past the hour, and I do want to get to a few more of
Sure,
these questions. Is that still good for you?
of course. I mean, I'm willing to be here as long as everybody has questions.
I got it. I gotcha. Good thing I didn't leave anything on the stove. I'm kidding. Everybody knows I'm not a great cook. Rick wants to know, is there any way to impose some reasonable ethical standards on the Supreme Court?
Yes, there is. It's a very good question, but it's not happening.
Right.
Congress could, but it's not. What would have to happen is both houses of Congress would have to pass and then sign. The president would have to sign into law these ethical standards. Now, what's curious is whether those ethical standards can be constitutionally imposed on the court would be decided by, drumroll please, the court itself.
Ah,
So,
okay.
right now, that's a big, big thing in
Yeah.
Congress, but it doesn't seem to be going anywhere. Yeah, I mean, as of right now, there doesn't seem to be a successful effort to prohibit Supreme Court justices from taking luxury vacations as gifts.
Mm-hmm. Yeah. I didn't realize how much I wanted to be a Supreme Court justice. I didn't realize there were so many perks aside from the outfit. I look amazing in black, can't you tell? Um, I'm sorry, Carly wants to know, is there a world in which the Supreme Court justices are chosen based on merit and not political appointees? And would achieving that help disrupt the politicization, it's such a hard word for me, of these positions?
Okay, you see, these are really deep and wonderful questions.
Regretting now that we didn't stop right at 8 o'clock?
Yeah. I mean, the Constitution provides for the presidential appointment of justices and the ratification or rejection of the appointment by the Senate. What this would mean, we would have to again amend the Constitution. It would mean that never again would who gets on the federal courts, particularly the Supreme Court, depend on who's president or who's in the Senate. It would mean there would have to be some independent commission which would, regardless of who's in office, appoint justices. Even that sounds promising. The question is, how do we keep ideologues off that commission? And what constitutes an ideologue? So I understand the need for non-ideological appointments of particularly Supreme Court justices. I just don't know how it could be done realistically.
Okay. Carol is asking, and I'm going to get this is a long one. What do you think of the far right justice? What do you think the far right justices are thinking when their decisions conflict with precedent and law? Doesn't being a Supreme Court justice mean one is supposed to keep an open mind and be persuaded by the evidence and the law, and certainly not merge with their religious beliefs with their decisions? Carol, you and I are of the same bent. And there's a part of me that's very idealistic and like, come on, you guys, you know what you signed on for. Stop, cut it out.
Of course, you see, again, one more very profound question. Let's look at the football coach case. The six vote majority knew very well that this coach wasn't going off by himself and reciting a little prayer. They knew from the photos, from the evidence, that he was convening in his job as a public high school football coach mass prayer meetings. They purposely ignored that to reach the ideological end.
Mm.
So what we have to confront is that right now we have, let's say, 6 justices, or sometimes we get 5.5 justices, who have the mission to create as much of a theocracy in America as they can. And it's easy for them to pretend that they are going by legitimate precedent and that they don't, that whatever their personal views are not being imposed. Such things, such judges and justices, we had some of them last century. And whether you agreed or disagreed with them, you could always trust their intellectual integrity. Today, unfortunately, we have come very far away from that. You see, if you were to tell Justice Gorsuch, look what you were ignoring when you wrote the majority opinion in the football coach case, he would say, oh, no, Justice Sotomayor was wrong. He was just off in a corner. He wasn't creating a coercive environment for his players, and nor was he commandeering the public high school football stadium for purposes of religious revival, even though the evidence showed that he was. I remember when Justice Barrett was nominated to be on the Seventh Circuit Federal Court of Appeal, and she was having trouble giving a straight answer about keeping one's religion out of a judge's decisions. And I remember California Senator Dianne Feinstein on the Judiciary Committee just looked at her and said, the dogma is all over you. And so the truth is, right now, religious right-wing presidents will do the best they can to appoint religious right-wing ideologues to the Supreme Court. Religious right-wing ideologue US senators will do the best they can to confirm them. Remember, when Ruth Bader Ginsburg died, Trump achieved the appointment of Barrett to replace her a week before he lost the election. Now, in 2016, even at the beginning of the year, when Scalia died, McConnell wouldn't let the Obama administration bring forth the nominee Merrick Garland.
I remember.
So, and when they asked McConnell, they said, this is a brazen power grab. You're using a double standard. And his answer was essentially, you bet.
Michael is asking, is it likely, no, I didn't want to ask that one. Well, yeah, we'll do that. Is it likely that the current court will overturn Kitzmiller versus Dover and allow creationism to be taught in schools?
Okay, that's a very, very good question. Kitzmiller was a decision by United States District Court judge that very, very cogently demonstrated that intelligent design was not science, but was theology. My fear is that the current Supreme Court could possibly uphold the teaching of creationism and intelligent design as alternative views. And here is a very scary reason. In 1987, much different court, in Edwards versus Aguilar, the last evolution creationism case before the court, we won. Our side won 7-2. Louisiana wanted creationism just to get equal time in the public schools. And the state wanted to argue that the reason, nothing to do with religion, but that there are reputable scientists who can assert that we all appeared spontaneously in our present form out of nowhere, but no need of a supernatural being to bring that about. At the time, Scalia and Chief Justice Rehnquist voted to let Louisiana make that argument, but the rest of the court did not. I'm afraid today that such a claim could even prevail. I mean, it's completely preposterous that everything in the universe, every living being spontaneously appeared in its already evolved current form, but we don't need any kind of deity or supernatural being to explain how that happened. See, this is the kind of brazen flouting of the law for ideological and religious purposes that's so dangerous.
Well, this brings us to this next question. How much of a threat is the Religious Freedom Restoration Act to circumvent secular and rational statuses?
It's been watered down. I remember in 1993 when it passed with the support of many civil libertarians, I was a lone voice standing up and saying, no, this isn't right, because what you're saying is that if you have a religious belief, particularly minority religious belief, you get to avoid complying with laws of general applicability, and non-believers don't have the same rights. An analogy I got from this was from the libertarian law professor Eugene Volokh many years ago. He gave this really, really good analogy. You've got two students in biology class at a public high school, public, so the First Amendment applies. One says, I don't want to dissect the frog because of religious reasons. The other says, I come from a secular philosophic tradition that doesn't want to dissect frogs. If only the religious objecting student is given the exemption and the secular one is not, that to me is an unconstitutional special privileging of religion. Our objective is that there are no rights that a religious claimant or objector has that's not available to everybody else.
I like that. I am the ew. I don't want to do it because it's icky, but and that never worked. That never worked. All right. You're technically all out of questions, but there was one that I am tickled to ask. So we maybe end on an interesting note. We fast forward. Kamala Harris has won. She gets to pick a Supreme Court justice. She calls you, sir. Do you accept her phone call and her nomination to be on the Supreme Court?
Of course, I would. Anybody. I mean, when she whoever is inaugurated on January 20th, I'll be 74 years old. So, I mean, there's nobody who cares about these issues on our side or their side who don't want the chance to do this, because look at how we view it, how they view it. Lawyers and judges on their side believe that they have to create the kingdom on earth and that they have to restore the hegemony of religion in government. People on our side believe that no government, is a very important way of wording it, no government anywhere should be able to take the view that some human beings have a correct interpretation of the will of the ultimate force in the universe, and that interpretation must be imposed on everyone. So because people on our side, lawyers, activists on our side, see the restoration of church-state separation as the equivalent of saving modern civilization and the Enlightenment. I mean, if I'm on my deathbed and I get a call, obviously, and also dyed-in-the-wool activists on issues, particularly when we think of ourselves as experts. I mean, I'll admit this too. We become legends in our own mind. I mean, I think that my arguments for church-state separation and for the true meaning of the religion clauses of the Constitution cannot be refuted by anybody in the country. I mean, I believe they're that sound. Um, Not everybody agrees with me. So the most important thing is that 2 calendar months from today is November 5th. We all know
Hmm.
what we have to do. We all know what we have to do in each and every state. And we have to be prepared that even if we get back modern secular government, depending on how severely we lose it, it may not be in our lifetimes, but that's okay. It's okay to devote yourself to a cause so great that you won't live to see the results, as long as you
Mm.
sort of pave the way for the restoration of the precious liberties that we're losing.
That's the kind of long-term thinking I think some of us have forgotten.
We
Eddie,
have no
thank
choice.
you.
Thank you.
Thank
Thank
thank you so much for your time tonight and braving through the tech issues. Your time and your contribution is very much appreciated. And I just want to remind everyone who's watching, if you missed any of tonight's presentation, it has been recorded and it will be available at skepticalinquirer.org and on YouTube. And as always, my thanks to Skeptical Inquirer, the Center for Inquiry, and of course to all of you in the audience. I'm very glad that we had this time together. My name is Leanne Lord. Thank you and good night. Eddie, thank you.
thank you.
It's always a pleasure to chat with you.
Thank you.
Good night, everybody.